I'll briefly start and apologize for the mask, but I'm not alone in the room. So welcome to everybody, and a particular welcome to Angelika Nußberger. This is my personal pleasure to welcome you to our meeting, and I'm very happy that you have agreed to talk to us. The introduction in substance will be made by my colleagues, and so I just stop here because I'm giving the floor to Riot again.
All right. So thanks for that short introduction. I'll give a short introduction to our talk today. But before I actually move into that, I just would like to mention that our talk today actually collides with the Thanksgiving on the one hand, and then also with the International Day for the elimination of violence against women. So we have darkness, light and darkness in both sides of these traditions. And as you most know, and I've already shortly said so, we meet once a month on the last Thursday of each month at 4 p.m. Central European time, which is to our great pleasure today to actually have made use for it so that Heinz Klug can join us from Madison. And we meet to speak of anything that relates to law, anti-Semitism, and seeing. So it's a very wide and open stage to be used to create a safe space for us to discuss things that are sometimes, or at least feel sometimes, not safe, and it could easily escalate and become too political or too politically correct to be, that we can't really say anything that makes sense. And on the other hand, we could say very offensive things on the other hand. So the idea here is to really create a safe platform to discuss these issues. As I mentioned, the presenter gets 25 to 30 minutes, which is then followed by a 10-minute comment by the commentator, and then the floor is open for questions and answers. Please feel free to use the chat or then to just raise your hand, either physical hand or the virtual one, and we'll collect questions. Before today I introduce our speakers, I'd just like to introduce I call it a younger sister, but it's not necessarily younger, but a sister project, our BMBF project that just commenced this summer, which is entitled As Just, so Anti-Semitism as a Challenge to the Judiciary. And I'll give the floor now to Dr. Nina Keller, who is the head, or she's the leader of the project, and then maybe Nika Lobrecht can say a couple of words. Nika was wonderful yesterday to organize our trip to the European Commission in Strasbourg, and was very a wonderful manager of a group of almost 40 students who went to see the premises. So Nina, please briefly describe the project for everybody, introduce yourself a bit, and then we continue.
Thanks a lot, Reut. I will keep it very, very short. I'm very happy to be here today and listening to the ABM Talks. It's really, really nice. Just shortly, as Reut said, my name is Nina Keller-Kemmerer, and I'm coordinating since October this year the project Struggling for Justice. It's a cooperation project. It's subsidized by the Bundesministerium für Bildung und Forschung for 3 years. It's a cooperation between different universities and RIAs, for example, as well. And it focuses on the question how the German judiciary system deals with anti-Semitism and which difficulties it is facing when dealing with it. So very roughly presented. So I'm very happy to be here today. Thank you.
Thank you. Nika, would you like to just say a couple of words?
Yes, hi, my name is Nika Lobrecht, and I work together with Dr. Nina Keller-Kemmerer on the BMBF founded project Struggling for Justice, Anti-Semitism as a Judicial Challenge. The sub-project I'm working on deals with fundamental and human rights in connection with anti-Semitism. So the aim of my project is to elaborate the impact of fundamental and human rights multipolarity on anti-Semitism. And for this purpose, I will examine judgments of the German Constitutional Court and the European Court of Human Rights and see how they capture and weigh the conflicting fundamental rights positions.
Okay, thank you so much. And thank you for keeping this very short. I'm just trying to make sure that everybody gets to say their thing today. So I would start with presenting Angelika Nußberger and then move to presenting our Anna Pingen. So Angelika Nußberger studied Slavic studies from 1982 to 1987, and then law from 1984 to 1989 at the Ludwigs University in Munich. She took her second state examination in Heidelberg in 1993. Angelika Nußberger received her doctorate in 1993 in Würzburg with a study on Soviet constitutional law in the transition period. In 1994 to 1995, she completed a research stay at Harvard and worked as a research assistant at the Max Planck Institute for Foreign and International Social Law from 1993 to 2001. From 2001 to 2002, she was the legal advisor to the Council of Europe in Strasbourg. And in 2002, she habilitated with a thesis on social standards in international law. In addition, she was appointed professor at the University of Cologne at the same year, where she headed the Institute for Eastern European Law and Comparative Law since then. In 2010, Angelika Nußberger was elected as a judge at the European Court of Human Rights by the Parliamentary Assembly of the Council of Europe. And on 1st of February in 2017, she was elected vice president of the European Court of Human Rights. She held this office until January 2020 and was the first German vice president of the European Court of Human Rights. After her return to the University of Cologne in 2020, so just last year, she became the director of the newly founded Academy for European Human Rights Protection. And just before I give the floor to Angelika, I'll introduce Anna Pingen, who is a part of our project and studied law at the University of Toulouse in France and at the University of Freiburg in Germany. During our studies as an exchange Erasmus student, she worked as a research assistant with Professor Ulrich Siebert at the Max Planck Institute, which she came back to later on. In 2015, she completed her bachelor's degree with a specialization in private law at the University of Toulouse. And after successfully completing her master's in 2016 at the same university, she returned to Germany to commence her doctorate studies at the Max Planck Institute in Freiburg under the supervision again of Professor Ulrich Siebert. She just completed, like a couple of weeks ago, she just completed with a summa cum laude her doctorate entitled Incitement, a comparison between German and French law. And during her studies thus far, she was also a part of the International Max Planck Research School for Comparative and Criminal Law. And she joined our project in the summer in June as a researcher and, as I said, completed her PhD that should be published very soon. And I'm very, very happy to be working with Anna, but also to have her comment on Professor Nußberger's presentation today. So please, Professor Nußberger, the floor is yours.
Yeah, thank you very much, Riot, for your introduction, and thank you for inviting me, and also warm hello to Thilo. We are old friends from old times, Heidelberg times, so it's nice to see you, Thilo. And happy to see you all, at least some of you I see on the screen. Well, I was asked to make a presentation within the project Seeing Anti-Semitism Through Law. And this has a subtitle, High Promises and Indeterminacies, and then a question mark. And I think the best I can convey to you today is a question mark, because I'm afraid I cannot give any answers, but I just raise questions. Building on my experience at the Strasbourg court, as a judge, you have to adjudicate a lot of cases, but some remain in your memory and some remain sort of undecided, or where you still feel, you had to decide, there is a yes or no in the end, but still you're not done with the case. It continues to move you. And that is for me the case Perinček, and that's why I want to to call my presentation the parent-check dilemma, because I still feel that there is something unsolved with this case. Actually, it's not a case about Holocaust denial. It's a different topic, but you will see that it's very closely linked to Holocaust denial, and it's sort of the elephant in the room of this case. Although we deal with something else, it's also about Holocaust denial. So let me just first explain in a few words what the case is about. Mr. Perinček is a doctor of laws and chairman of the Turkish Workers' Party. In 2005, he took part in several events in different cities in Switzerland. And there he publicly denied that there had been any genocide of the Armenian people by the Ottoman Empire in 1915 and subsequent years. In particular, he described the idea of an Armenian genocide as, I quote literally, international lie. His comments were made in different contexts, at a press conference in Lausanne in Turkish, at a press conference in Opfikon commemorating the 1923 Treaty of Lausanne, and at a meeting of his party in Königs. So 3 times. This was sanctioned under Swiss law as a criminal act, or these 3 remarks were sanctioned under Swiss law under Article 261, paragraph 4. And let me just quote what is written in the Swiss Criminal Court. It's the general paragraph sanctioning racial hatred and discrimination. So that's what it's about. And there it says, I quote, "Any person who publicly denigrates or discriminates against a person or group of persons on the ground of their race, ethnic origin, or religion in a manner that violates human dignity, whether through words, written material, images, gestures, acts of aggression, or other means." And then, that's now the important part, "or any person who on the same ground denies, grossly trivializes, or seeks to justify a genocide or other crimes against humanity." So all those, and then shall be punishable by a custodial sentence of up to 3 years or a fine. So this was the legal basis for the condemnation of the denial of the genocide of the Armenian people. This was the first instance judgment, and the applicant appealed. In his appeal, he argued that it would be necessary to establish the state of research and the position of historians on the Armenian question. The second instance court dismissed his complaint, and now in this context, they compared or they referred to the Holocaust. And that's where now our topic comes in. So the Swiss Court of Appeal argued that the Armenian genocide had, in the same way as what they say the Jewish genocide, had been recognized by the Swiss legislator as a proven historical fact. And therefore they argue that it's not necessary to refer to the work of historians in order to accept its existence. They also stress that Mr. Perinček has not denied the facts of killing a very high number of Armenians, but he was only focusing on the legal qualification, not on the facts as such, but only on the legal qualification as genocide. So we see here the Swiss courts argue with a comparison between Holocaust and the mass murder of the Armenians. The case was then brought to the Swiss Supreme Court. The Swiss Supreme Court very much focused on the wording of the paragraph that I have read to you, and there what we find is a genocide. So the indeterminate article, it's denies, grossly trivializes, or seeks to justify a genocide or other crimes against humanity. So this is open. It's an open, sort of an open-ended wording. Now the Swiss Supreme Court argues, also going back to the legislature's intention at that time, what this paragraph, what this article means. And in this context, they say that in the debate in the Swiss parliament, it was clear that the Holocaust is an undeniable fact. At the same time, they say other potential genocides, for them, it's necessary to assess and characterize them. And there has to be some general assessment of the characterization as genocide, as they argue, both among the public and within the community of historians. So in this sense, with reference to what is meant by the legislature, there's a differentiation. The Holocaust is seen as an undeniable fact, whereas the genocide of the Armenians is sort of based on the fact of a consensus among whom, that's the question, consensus of whom. There are three options, whose assessments, so courts, historians, or states. And there now the Supreme Court argues that it's not necessary for a genocide to have a confirmation by a court, by an international court or another court, but it mainly refers to historians, the opinions of historians. And there what they say, that there is a, I quote, wide academic consensus as to the classification of the events of 1915 as genocide. And they say, I quote once more, there is enough of a general consensus, so not unanimity, but enough of a general consensus. And then they add, especially among historians. So not only among historians, but especially among historians. That's their argument. Concerning states, they once more compare to the Holocaust, and they say that it's not necessary to have a confirmation by states. And they refer to the UN resolution on Holocaust, condemning Holocaust denial, adopted in January 2007. And they say, well, it was received only by 103 votes from among 192 states, but in their opinion, that is not relevant, as there are or maybe political considerations behind accepting this resolution or not accepting it. So states' assessment does not count, but historians' assessment. So the summary is, I quote, that being so, the appellant has not shown how the police court, so there was the first court, the police court acted arbitrarily in finding that there was a general consensus, particularly among academics, as to the classification of the events of 1915 as genocide. It follows that the cantonal authorities were correct in refusing to allow the appellant's attempt to open a historical and legal debate on the issue. So that is their finding. They link it to the protection of human dignity of the members of the Armenian community who identify themselves through the memory of the 1915 genocide. So what do we see in this case in front of the Swiss courts? They compare to the Holocaust denial, but they don't put it really on the same level, because one is undeniable, the other one you have a necessity of assessment. But then, as a consequence, in practical terms, they treat it in the same way, because they argue that there is a general consensus among historians. In both cases, they see racist motives behind. In both cases, they see it linked to the dignity and identity of the victims. And as a restriction of freedom of expression, they argue that it's foreseeable. That's now the national level, and that's the case that was brought to the European Court of Human Rights. And now we have an assessment on the European level. So for 47 states, no longer within the sort of framework of one state only. And we have the human rights question, the tension between freedom of expression and freedom of debate on historical events on the one hand, and on the other hand, the necessity to safeguard a specific narrative of the past that is linked with the identity and dignity of a specific people, of the victims. So let's look at the court's approach to such questions. The court has been quite often confronted with questions of linked to the Holocaust denial in different contexts, and of course it had to build on its former jurisprudence. In my view, now in these cases in 2013 and 2014, the court was at a crossroad. In my view, there were now different possibilities how to argue. It could, on the one hand, just accept this, the Holocaust, the prohibition of the Holocaust denial that was always considered to be compatible with freedom of expression. It could consider this as a unique, so the only exception to the protection of freedom of expression. Or it could transfer it, and it could transfer it in a broad, in a narrow way, just to other potential genocides, or it could even have could transfer it to his specific historical narratives in a more general way that are linked to difficult, sensitive problems concerning the identity and dignity of other peoples. We can think of colonialism, of communism, of victims in this context. So it's different. There are different possibilities of opening up, sort of restricting further freedom of expression and opening up the protective approach to identity claims. Or it could sort of put aside its long-standing approach of accepting the prohibition of Holocaust denial and could go for a much more open and liberal understanding of freedom of expression as we know it, for example, in the United States. In my view, that is, I said it was a crossroad. It was the first such case, which came first before the chamber and then before the Grand Chamber, but it has to be seen against the background in Europe of a lot of memory laws that are being adopted on specific narratives of the past that are often enshrined even on the constitutional level. In general, the court had a twofold approach to such cases, either under Article 17, declare them inadmissible immediately, as not covered, as the message conveyed is not covered by the convention at all, or under Article 10, and then discuss in how far the restriction on freedom of expression is justified. So Article 17 is sort of the radical approach. And there, you know, Article 17, I just quoted, nothing in this convention may be interpreted as implying for any state, group, or person any right to engage in any activity or perform any act aimed at the destruction of any of the rights and freedoms that set forth herein, or at the limitation to a greater extent than is provided in the convention. So basically, that means arguing or speaking out against the basic values of the convention is not protected by the convention. So has this been used in such cases? Yes, the court does have a twofold approach under Article 17 and under Article 10. And it has built up its jurisprudence. There is a case, Lehedieu and Isoni versus France, which was about Pétain and a statement that put Pétain in a positive light. It was linked to public defense of war crimes, of collaboration in France. And there the court said, these are not clearly established historical facts contrasted to the Holocaust. So this example was there. And therefore, as there is an ongoing debate, it cannot be brought under Article 17, but it has to be discussed as an argument that can be brought under Article 10. The same was the court's approach in Orban and others versus France, where it was about torture and summary executions in Algeria. There as well, it was said to speak out in favor of them is not something that is sort of not protected as free speech. It's always also political speech. But on the contrary, Holocaust denial as such is brought under Article 17, and the respective cases are declared inadmissible, like Garodi versus France. The conviction for the denial of crimes against humanity and crimes perpetrated by the Nazis against the Jewish community is considered incompatible ratione materiae. So to say something like that is just not protected, and that means you don't have to go into anything like justification. And there in those judgments, we always find this repeated sentence category of clearly established historical facts, such as the Holocaust, whose negation or revision would be removed from the protection of Article 10 by Article 17. Article 17 was then also used for other clearly anti-Semitic speech, not linked to Holocaust denial, like in Pavel Ivanov, but also to Islamophobic speech, like in Norwood versus the United Kingdom. So Article 17 is not applied in Perinček. It's about the qualification, the legal qualification of Holocaust denial and not Holocaust denial as such. So the court brings it both in the chamber and in the grand chamber under Article 10. Under Article 10, we have the problem that the basic idea of Article 10 is that political speech should not be restricted at all. And you might all know this famous formula that says, we don't have to protect ideas that everybody likes to hear, but what we have to protect is ideas, I quote, that offend, shock, and disturb. So, of course, Holocaust denial offends, shocks, and disturbs. So the question is where to draw the limits of what sort of offending, shocking, and disturbing is generally accepted. If we look at the German cases, we can say that the court grants a sort of German exception. So we have cases concerning comparison to Holocaust, which are not exactly Holocaust denial cases, but just comparing other atrocities or other negative facts to the Holocaust, and the German courts are very strict and prohibit them, and the court would always accept it. So one example is Hoffer and Annen versus Germany about abortion, anti-abortion leaflet comparing baby cause to Holocaust. And there a specific doctor, a medical doctor, was attacked, and the court argued that the violation of the physician's personality rights was particularly serious, and that's why it was allowed to prohibit this comparison, because he was an abortion doctor, to call it baby caused as an allusion to the Holocaust. And the other probably famous case that you might know is Pita versus Germany in 2012, about two pictures, one of the Holocaust and one of a plate with food, sort of shown together, and with a subscription Holocaust on your plate. So comparing what is happening to animals to what happened to the victims during the Holocaust. So it was not meant as stirring racial hatred or anything like that. It was just meant to drive home the message that for animals, what is happening is really extremely bad. But nevertheless, the German courts prohibited this speech, and the European Court accepted it, arguing that it's an instrumentalization of the plaintiff's suffering. It's a banalization, and it even said literally the fact that it's not prohibited everywhere, but only in Germany, because in Austria it was actually allowed, the same poster was allowed. It was said this is not called into question by the fact that courts in other jurisdictions might address similar issues in a different way. So we have the repetition of the sentence or the wording specific context in the German past that is repeated again and again to justify the wide encroachment into freedom of expression in Germany in such cases. So this is the background, the jurisprudence, both on Article 17 and on Article 10. And now let's come to the Perinček case. What could the court do? Transfer this restrictive or this protective jurisprudence on Holocaust denial to the Armenian genocide or not? So this is the question. There were many judges dealing with this case. So it was on the chamber level, on the grand chamber level. So in all, you had 24 judges sort of reflecting on the case. And the majority of them decided that basically it cannot be transferred. It's different. Holocaust denial is different, and Holocaust denial can be sanctioned, whereas what Mr. Perinček had done could not be sanctioned. So it was both on the level of the chamber and the grand chamber, it was were judgments in favor of freedom of expression. But the problem was how to differentiate, how to uphold this long-standing jurisprudence on Holocaust denial, which was restrictive, and now to say, no, you can't transfer it to another genocide like the Armenian genocide. On the chamber level, the way how to differentiate Holocaust denial and Armenian genocide was basically something like, I would call it a theory of doubt. So it went back to this undeniable for the Holocaust, whereas it argued that they were not so sure about what happened in Armenia. And I quote the chamber judgment. It said, in any event, it is even doubtful that there can be a general consensus, particularly among academics. So that's what the Swiss argued existed about events such as those in issue in the present case, given that historical research is by definition subject to controversy and dispute and does not really lend itself to definitive conclusions or the assertion of objective and absolute truth. In this connection, and now important, in this connection, a clear distinction can be made between the present case and cases concerning denial of crimes relating to the Holocaust. So that's how they differentiate. And then they argue that Perinček has not denied the historical facts, but it's only about legal qualification. And then second, they argue that for Holocaust denial, there was a clear legal basis in the Nuremberg Charter. And third, the historical facts challenged by the applicants have been found by an international court to be clearly established. So that is the way they differentiated. One is clear and undisputable. The other one is at least not as clear, and that's not sufficient to restrict freedom of expression. There was a huge outcry after this judgment, both in Switzerland and I think in the Armenian community, and actually, I don't know worldwide, I don't want to exaggerate, but there was a real outcry. It was understood that it's unacceptable to sort of argue that there are so many doubts about the Armenian genocide that it should be accepted that that is not something you can have doubts about. So the case was brought to the Grand Chamber. As I said, the Grand Chamber came to the same conclusion, but it tried to find different arguments. to differentiate once again the big question, how to differentiate to Holocaust denial. And there they say, I quote for the court, the justification for making its denial a criminal offense lies not so much in that it is a clearly established historical fact, but that in view of the, it argues in view of the historical context. So not doubts or not doubts, but different historical context. And there the court tries to now to make it sort of transferable or to establish general criteria. And it argues that there are geographical, historical, and time factors that are different for different cases. And concerning geographical and historical factors, they argue that Holocaust denial is per se, it's seen as connoting an, I quote, anti-democratic ideology and anti-Semitism. So per se, denying Holocaust is linked to, or is understood to be linked to a certain ideology. And that applies in the court's view in cases concerning Austria, Belgium, Germany, and France. Second point concerning geographical and historical factors is what it's called a special moral responsibility to distance themselves, so for the people living in those countries I've just mentioned, from the mass atrocities that they have perpetrated or abetted by, among other things, outlawing their denial. So second aspect under this geographical and historical factors, special moral responsibility. And the third factor, the time factor, there it said, well, it's different if something is closer in time or if a lot of many years have passed, and they argue that it's inappropriate to deal with what has happened at different time periods with the same severity. So they try to, the judges try, or the court tries to give a rational distinction why it's possible to prohibit Holocaust denial, but why it's not possible to prohibit the denial of the Armenian genocide. It tries to give rational arguments, but in my view, basically it boils down to the fact that the Holocaust is unique. And there it says also in this judgment, the only cases in which it had been accepted is the Holocaust denial up to there. And there it stresses once again the very particular context and the fact that it's regarded as particularly upsetting. So basically the argument is uniqueness as so to the concerning the jurisprudence so far it's only applicable this to the Holocaust. I was sitting in the case and I found the argumentation of the majority of judges not convincing, to be honest. I think it's absolutely correct to say that context matters, but is it really true that Holocaust denial is less dangerous if it's closely connected in time? So is it more dangerous in 1960 than in 1980 or in 2020? I think we have really obvious evidence of contrary developments. Nowadays, we are many years after the Holocaust, and still the Holocaust denial has the same devastating effects, I would argue. And is it really true that it's less dangerous to argue to deny the Holocaust when you live in Switzerland or when you live in Australia than when you live in Germany or France? I think it's very difficult to justify if you look about the identity and dignity of the people concerned. So why should there be a difference? So in my view, it basically boils down to this fact of saying, well, that is just unique. Can we accept such such a finding without really good arguments that it's unique. I think there are arguments in favor of that. We can say, well, the background of drawing up, of drafting the convention, that's the Holocaust. I mean, the convention was, they started to draft it in 48, 49. So immediately after it had happened, it was a direct response. So I think this would at least be an argument to say, well, this treaty was made as an answer to the Holocaust. So this is an heritage of the treaty. It's also possible to argue, well, freedom of expression, freedom of political speech has to be granted in a very broad way. So whenever we have exceptions, they should be very, very, very narrow. And that's why we keep them and apply them only to such one phenomenon. And we can also argue that we have the experience that Holocaust denial is regularly linked to other phenomena like not living peacefully together. So that is also something where we can look at our experience. So these might be arguments in favor of this uniqueness approach, but on the other hand, what is an argument against? It could be understood as neglecting the suffering of others. That is a very serious argument. Or to quote my colleague Ulat Belavuza, who said it's the disquieting specter of a hierarchy of atrocities. I think that's also a valid argument. So I felt very uneasy sitting in the case. I wanted to uphold freedom of expression and especially freedom of historical debate. But at the same time, I did not want to endanger in any way the court's jurisprudence concerning Holocaust denial cases. So if I may just quote my partly dissenting opinion, I wrote, assessing, evaluating, and commenting on historical events are prerequisites for living peacefully together in society, being conscious of what has happened in the past and assuming responsibility where necessary. There's not one historical truth that could remain permanently immutable. On the contrary, new research and new discoveries of documents and evidence may shed new light on what has been deemed to be an uncontested view. So I wanted to speak out clearly in favor of being able to debate on history. At the same time, I wanted to allow different states to legislate in a way to be sensitive to their specific past. And that's why I argued legislation expressing solidarity with victims of genocide and crimes against humanity must be possible everywhere, even if there are no direct links to the events or the victims, even if a long period of time has elapsed, and even if the legislation is not directly aimed at preventing conflicts. Each society must be free to settle the conflict between free and unrestricted debate on historical events and the personality rights of victims and their descendants in accordance with its vision of historical justice in the case of what is alleged to be a genocide. So that was where I saw both sides of the coin, what is necessary. In the end, I found a procedural violation. I thought that having a legal norm that prohibits speaking about a genocide, so this indeterminate genocide, that is not clear enough. What really is the consensus in the respective society? What is sanctioned and what is not sanctioned? That was my solution to the case. But as I said, I'm still reflecting on this case, and I still think that it's very, very difficult to solve. I understand that we have now what is called a second historical struggle, einen zweiten Historikerstreit. So this question about the uniqueness of the Holocaust comes up in a different manner. It's on the one hand, each comparison is understood to qualify and relativize the remembrance of the Holocaust and is per se not acceptable. On the other hand, it's argued that there are comparable injustices and the exclusive focus on the Holocaust is used as a pretext or an excuse not to deal with other atrocities in sufficient depth, like with colonialism. So this is actually, I don't want to join in the second Historikerstreit. I just want to bring in the perspective of human rights debate about freedom of expression. And so, as I said, I leave you with a question. I cannot give you the answer. What should be done? Is it better to have a really liberal understanding, to give up this restrictive Holocaust denial jurisprudence, or at least to differentiate it? And when we talk only about legal qualification, not to be so strict unless it's really meant to be denigrating and insulting, or should we keep this approach of a narrow restriction of freedom of expression, only allowing prohibition of Holocaust denial, but not other historical narratives? Or should we be more open and transfer it to other mass atrocities, or even broaden it in favor of a more emotion-sensitive speech on historical injustice? So I do see that there are good arguments for all these approaches, and I'm very interested what you think. Perhaps you can help me to solve the parent-check dilemma many years after I was confronted with it. Thank you very much.
Thank you very much. This was amazing and very timely. As you mentioned, the second Historikerstreit, and I have lots I could say, but I would give the floor to Anna Pingen to make her comment, please.
Thank you so much, and thank you for the opportunity to comment. I'm afraid that I'm going to add more questions, so be prepared. Also, I'm going to look at it maybe with a view of a criminal law specialist on it, so might be a bit different. So in the context of the commentary, I would first like to take a step back and ask, what is the purpose of criminalizing denial of genocide in general? It can be, one, to prevent future criminal acts. By doing so, we want to protect the rights of individuals a priori, or two, to protect the rights already harmed by denial itself, such as the dignity of victims. The first preventive purpose raises a question that is sadly not often discussed in criminal law doctrine or case law. More specifically, if someone is punished for the fact that his or her statement may indirectly motivate a third party to commit a criminal offense and thus impair individual legal interests of others, how should such potential impairment be indirectly motivated how the impairment could be attributed to the responsibility of the actor who issued the statement in the first place. With regard to the concept of responsible citizen, the motivated actor must also be regarded as a responsible citizen, and not every factual influence of the first actor on his or her behavior can be sufficient to establish the liability of the first actor. Rather, it is necessary that the statement of the first actor has such criminogenic quality that would justify attributing the criminal responsibility to him or her. A corresponding quality is provided if the statement, according to its objective content, actively aims towards the commission of one or more offenses in the future. The inciting statement must express a certain pressure to act or to call to an action, meaning that the incitement must formulate the expectation of an act in which mens rea of the person who incites is reflected. In this respect, a situational climate or a simple statement alone are not sufficient to build up pressure to act, and are therefore not enough to justify imputability. I think that in this sense, the refinement of the European Court's jurisprudence on the application on the application of Article 17, which the Perinček case facilitated and which holds that the abuse clause may only apply to expressions that are directed to stir up hatred or violence, seems a move in the right direction. A move in the right direction because of 2 points. First, it clarifies what quality a statement should have in order not to be protected by Article 10 of the European Convention. Second, it also answers the mirroring question, namely, what quality the statement should have in order to justify the imputability of criminal responsibility to the person who makes it and justify the criminalization of such an offense. In this regard, it is important to note that Article 17, which removes from the protection of the Convention any activity aimed at destroying any of the rights set forth in the European Convention, was first envisaged to apply to activities that run counter to the basic values underlining the Convention, including expressions denying clearly established historical facts and crimes against humanity. In following jurisprudence, the court added that Article 17 also covers statements aimed at justifying war crimes, such as torture or summary executions, or the glorification of war crimes, crimes against humanity, or genocide. With regard to genocide denied, the abuse clause has thus far been applied only to a specific type of denialism, the denial of Holocaust. In the Perinček case, regarding the denial of the Armenian genocide, the court resolved to refine its jurisprudence on denial. The Grand Chamber thus found that the decisive point under the abuse clause is whether the conduct sought to stir up hatred or violence, and the applicants sought to rely on the Convention to engage in activities aimed at the destruction of the rights encapsulated therein. This provision, therefore, may not be applied to denial of genocide as such, absent a case-specific assessment as to whether such statements are intended to provoke hatred or violent action. That is to say, if the assertion can be characterized as hate speech. Understanding genocide denied in relation to incitement and hate speech, as the court does, seems to make it clear that not every denial is going to be covered by Article 17. This exclusion of simple denial also goes in the direction of needing a certain quality of the statement in order to justify the attribution of responsibility and the criminalization of such a conduct. But this development must be nuanced because of 2 aspects. First, the requirement that the denial of genocide must be associated with an incitement to hatred or violence must be juxtaposed to the court's position on hate speech, which brings within the scope of the abuse clause even those expressions devoid of any calls for unlawful conduct or violent action. In the case of hate speech, the abuse clause does not only target explicit and straightforward statement, but also extends to more subtle and elusive forms of expressions, as it has been said in the Mbala case from the European Court in 2015. Including such subtle forms makes it clear that the gist of the court's assessment is likely going to be a very subjective assessment, open to a wide spectrum of diverging understandings as to what can be seen as incitement. This blurred frontier between explicit and tacit hate speech may have a chilling effect and produce a climate of self-censorship on those opinions that offend, shock, or disturb the state or any sector of the population, which the court has long proclaimed should be permitted. Further, the European Court's case law, especially the Perinček case, shows the importance attributed to the context of the statement to determine if the statement constitutes a danger or an incitement. While the context might play a role, it seems kind of arbitrary and volatile to see in the context the most important and prominent criterion to determine the inciting character of a statement. It not only gives the court a wide margin of appreciation, but also makes it more difficult for the citizen to determine when the statement enters illicit territory. Second, the automatic presumption that the court affirmed with the Perinček case regarding the denial of the Holocaust, and in which for historical and contextual reasons, it had invariably presumed the inciting character of statements denying the Holocaust in those states which experienced the Nazi horrors, seems going in the opposite direction. It undermines the new added element to the topic. The idea that for a criminal sanction to be justified, the statement must be associated with an incitement to hatred or violence. The same automatic presumption is declared to be inapplicable to the Perinček case, apparently on the grounds of a geographical and temporal distance between the applicant's expression made in Switzerland and the destruction of the Armenians in the Ottoman Empire. Further, the concept of automatic presumption and the main arguments based on the geographical context and the passage of time used by the court to distinguish Holocaust denial from the denial of the Armenian genocide or any genocide are problematic from criminological and moral standpoints. First, arguing for the automatic exclusion of the locally specific Holocaust denials from the protection of the convention on the grounds of special moral responsibility shared by the states participating in Nazi crimes negates the similarity in the criminology of genocide across different geographical and temporal contexts. Genocide does not emerge from vacuum. It develops gradually as a process where the widespread destruction of a certain group is preceded by different discriminatory practices towards members of that group that gradually increases in intensity. The rift among social groups as the result of the genocide remains for a long time in post-genocide societies and can be a risk factor for the renewal of discriminatory practices, especially in societies where the legacy of past genocides have not been adequately addressed. This is also indicated by the UN Framework of Analysis of Atrocity Crimes from 2017. In other words, if the risk factors for new discriminatory practices, such as bias-motivated violence, which the Holocaust denial can contribute to, are deemed present by default in Germany, Austria, France, or Belgium, as the concept of special moral responsibility would imply, why shouldn't they be present in other post-genocide societies? Second, from the moral standpoint, the automatic presumption with regard to the Holocaust seems to imply a tacit hierarchy among genocides, which undermines the development of a global collective conscience premised on intolerance toward any form of international crimes, including genocide of any sort. The European Court might further be contributing with this distinction between the genocides to a competitive victimhood, a process by which groups attempt to establish that they have suffered more than other groups in order to restore feelings of moral identity, and that is often for use in a political context. Such competitive victimhood contributes to conflict escalation and impedes their peaceful resolution. With regard to the second purpose of denial of genocide offense, namely the justification of the existence of an offense criminalizing the denial of genocide through the protection of the dignity of the victims, it might be argued that this dignity is already protected through existing legislation in different member states on the punishment of insults and discrimination. This is more like a question. Does this existing legislation already cover grounds that would be covered by the denial, or does it not? At the same time, the incrimination of the denial of genocide might be seen in the context of reinforcing the global collective conscience with regard to intolerance toward international crimes. As Professor Nußberger wrote in her partly dissenting opinion, it might be a choice of society to seek to vindicate the right of victims of mass atrocities, and you might argue that the possibility for legislation to express solidarity with victims of genocide and crimes against humanity must exist. But I have my doubts if this is going to be achieved through criminal law, if criminal law is the right medium to express solidarity. Here again, it could be argued that the criminalization is needed to create a collective conscience as an expression of reproof on international crimes. But the question remains if criminal law is the right answer, as criminal sanctions should be an ultima ratio. Many scholars have already denied the need for the intervention of criminal legislator in this field, in which preventive measures of information, administrative sanctions, or civil protection should be enough. The punishment of denialism could be moved from the level of criminal law to the private law area, thereby reinforcing the civil protection of the victims. But here again, some questions come. This perspective creates the problem of identifying the avoidable damages and the instruments to quantify them. I agree with Professor Nußberger on the point that if there is such offense concerning the denial, it has to be clear, determined, and that simply referring to a genocide poses a lot of questions and problems. But yeah, as you see, I only had more questions than I could answer. And yeah, thank you.
Thank you very much to both our wonderful speakers today.